So first and foremost, we would like to thank everyone for joining us this afternoon. Good afternoon. Thank you for spending your valuable lunch hour with Nick and myself to talk about the wild, thrilling world of TILA compliance and our favorite federal and state alphabet soup statutes. By way of introduction, my name is Sara Solano. I'm an associate in the Fort Lauderdale office of Burr and Foreman. I have been with Burr since my summer associate tenure in 2014 and have been a full-time associate ever since. My practice is primarily in the consumer finance realm with Nick, and I guess as a little fun fact about me, when I'm not bothering Nick down the hall with questions, I can be seen in Delray Beach, Florida doing improv comedy. So I will turn it over to Nick for a brief introduction as well.
Thanks, Sarah, and thank you to everyone for joining. We're looking forward to digging into some TILA today. My name's Nick Agnello. I'm a partner at Burr and Foreman. I've been with Burr for over 10 years now. And this past weekend, I threw my 5-year-old daughter a rainbow unicorn birthday party. And the only thing that can be more fun than that is a little TILA compliance. So without further ado, start digging into it. So the FDCPA will be well known to everyone on the call. It covers a lot of different activities, and it contains a number of different prohibitions. It regulates communications with third parties, communications with the consumer, harassment or abuse, false or misleading representation, unfair practices, debt validation and debt collection lawsuits, and generally regulates all these things in the context of debt collection and with respect to debt collectors. So the definition of debt collector under the FDCPA is fairly broad, but it does contain a number of limitations, including its application to businesses whose principal purpose is the collection of debts, or regularly collecting directly or indirectly debts owed or due to be asserted to be owed or due. So there's a longstanding exception with respect to any person who is collecting a debt that was not in default at the time it was obtained by such person. So that's usually going to not cover your creditors or even some of your loan servicing that is not with respect to loans in default. So the FDCPA damages provisions are fairly common amongst consumer protection statutes. It provides for actual damages, statutory damages up to $1,000 and reasonable attorney's fees and costs. That last one ensures that it is a constant source of litigation from a robust consumer bar. It also provides for class actions with a class actions damages limitation of the lesser of $500,000 or 1% of the net worth of the defendant. So I'll pass this over now to Sara, who will discuss Article 3 standing.
Sure. So in the federal context, to maintain a federal court action, Article 3 requires a case in controversy, which requires a concrete injury in fact. So purely informational harm that does not have some sort of concrete basis of damages without more to demonstrate that requisite concrete injury is not sufficient to maintain standing under the FDCPA, and that's something that the 11th Circuit has touched upon. There are breach of privacy concerns. That's something that was raised in the Hunstein case, which is currently on appeal. So we are currently monitoring that for future rulings on that issue. As we noted on the slide, the oral argument was heard en banc in February of 2022. So that was only a few months ago, so we can't expect to hear something on that issue very shortly. So we will continue to monitor that going forward. And now pivoting into the state realm, the FDCPA is again something that many of you are likely quite familiar with. Under 55972, the FCCPA outlines many of the different ways in which debt collection may be deemed problematic in terms of liability. And I've noted here on this slide some of the more frequent bases for liability that we've seen. Subsection 7 is willful communications with the debtor, to a degree with which to be harassing, and generally subsection 7 is invoked for things like telephone calls and are oftentimes paired with TCPA and related claims. Subsection 9, threatening or attempting to enforce a debt that the creditor knows to be unenforceable. That's usually something that will crop up in the context of a disputed debt or something related to identity theft, oftentimes paired with a Fair Credit Reporting Act claim. Subsection 17, communication with the debtor between certain hours. Multiple states have different time periods in which creditors or debt collectors can communicate with debtors, and under Florida, that's between 9 p.m. and 8 a.m. Without prior consent. And finally, subsection 18, which is probably what we're seeing a lot of currently, which is communications with debtors after the creditor knows that the debtor is currently represented by counsel. So we see these cases in a multitude of contexts. Letters of representation are often faxed or mailed to the creditor, and either those letters are processed correctly, but there is a brief delay between processing and the ceasing of communications. Sometimes those letters are not received, either they were misrouted or there's some sort of dispute as to whether the letter was sent, or sometimes the letters were sent, received, and processed correctly, but the internal procedures for the business dictate that monthly statements should have continued going directly to the debtor rather than to debtor's counsel due to concerns with remaining in compliance with TILA. And so where does the FCCPA apply? Now, this is kind of where the FCCPA diverts a bit from its federal cousin. While the FDCPA is limited to what federal courts have defined to mean a debt collector, the FCCPA has broader applicability and includes direct lenders. So for certain cases where direct lenders and creditors have managed to avoid FDCPA liability because they don't meet that debt collector definition in federal contexts, they will likely have liability here under the broad definition under the FCCPA. However, the damages provision is quite similar to the FDCPA. We have the same scheme of damages up to $1,000 of statutory damages and the ability to recover reasonable attorney's fees and costs for individual suits, which again makes it quite tempting claim to bring for the plaintiff's bar, and the same scheme for class actions is seen in the FDCPA. And, just kind of touching again on the interplay between the two statutes, the statute itself for the FCCPA specifically invokes the federal guidance for the FDCPA, and that's been recognized in both federal courts and Florida courts interpreting the FCCPA, that Florida courts will defer quite greatly to their federal counterparts for how to apply the FCCPA in similar contexts where those claims are either brought together or FCCPA claims stand on their own. And so Nick will talk about legally required communications and do those constitute attempts to collect a debt.
Thanks, Sarah. So the thrust of this presentation, now we've sort of gone over the basics, is a set of arguments that have been raised for a long time about the interplay and at times the tension between the FDCPA, the FCCPA, and other federal statutes, particularly TILA. And the argument arises frequently that the violation of the FDCPA or the FCCPA is contained in some kind of legally required notice. So an FDCPA debt validation letter, or a monthly mortgage statement, or a credit card statement, or a monthly bank statement, something that the law says has to be sent to the consumer, and then they turn around and say that it is somehow in violation of these statutes. So a lot of that then turns on, are those legally required notices an attempt to collect a debt or related to debt collection? And so the case law going back historically within the 11th Circuit looked, first at a pretty classic dunning letter that advised the borrowers that they were in default, told them that they needed to make a payment by a certain date, or a legal action would be commenced against them. And there was a question of whether or not that could give rise to these kinds of claims if it was done by a law firm, as was the case in the Reese opinion, and whether or not these were covered communications, and the 11th Circuit held that they were. The Caceres case came later and asked, just because the letter references the debt, where do we draw the line at what constitutes debt collection that would be covered by these acts? And the test began to be whether or not the aim of the letter is to induce the debtor to pay. And that can obviously be done with an explicit demand for payment. And in Al-Asid, a case that came after Caceres, the court looked at, well, what about if there's an implicit demand for payment? And then where do we draw the line? What if the notice is purely informational? It tells them that there is a debt, that it's in default, but it does not make an implicit or explicit demand for payment, and the court held that that was not covered by the FDCPA. So you see a bit of a sliding scale. You have everything from the classic attempt to collect a debt with a dunning letter to something that is more middle of the road and the applicable test, which is to look at the aim of the communication. And then you have the opposite end of the spectrum, which is a purely informational letter that is about the debt, but is not seeking to and making an attempt to collect on it. So the other thing that we've seen is that the regulators have provided some guidance, not expressly on point with the question that we're going to get to with some more recent 11th Circuit case law, but at least on the interplay of some TILA requirements in the FDCPA and how to harmonize those. So one of the questions that was raised to the CFPB was, if I get a notice that says a borrower wants me to cease and desist my collection activity and communications, do I violate it by sending them a monthly mortgage statement? And the CFPB said no, that generally speaking, Congress in its infinite wisdom has decided that monthly mortgage statements or other periodic statements required by the Truth in Lending Act, so also your credit card statements, are information that's useful to a consumer, and that we want the consumer to get that even if they're not, even if you're not able to continue debt collection communications. So some people read this as saying that those communications would not constitute debt collection. Others read this for a more narrow proposition, that you could still continue sending legally required TILA statements to borrowers after a cease and desist. It certainly stands for that proposition. Of course, this kind of guidance is oftentimes not binding in court, and the courts are able to deem these kinds of analyses, incomplete or incorrect. So we'll look a little bit more at how the 11th Circuit looked at this analysis when we get to the Daniels case, which Sara is going to talk about now.
Yes, so that brings us to the case of the hour, what we're what we're all here for. So we'll start at the beginning, at the lower court's opinion, the Middle District of Florida's opinion that it issued in December 2018 that gave rise to the appeal. So the underlying case involves an amended complaint that the consumer filed alleging that monthly mortgage statements that had been sent by the mortgage servicer SPS violated the FCCPA and FDCPA because those statements constituted improper debt collection communications. In response, SPS had filed a motion to dismiss, arguing that the monthly statements could not be debt collection as they were sent in compliance with TILA and Reg Z. In granting that motion, the Middle District of Florida noted that the monthly statements at issue appeared to be in conformity with TILA and were basically substantially similar to the model forms that the CFPB had promulgated, stating that, hey, this is what a monthly statement should look like, and did not find any major deviations. So in its holding, the Middle District stated that any minor discrepancies in the language, when taken in the context of the document as a whole, did not constitute debt collection and did not take those statements out of the informational realm of monthly mortgage statements and suddenly convert them into being debt collection. So the consumer appealed, and the case was thereafter adjudicated by the 11th Circuit. And there, the 11th Circuit considered a question of first impression, whether monthly mortgage statements that are required by TILA Reg Z can constitute communications in connection with the collection of a debt under the FDCPA and the FCCPA. Unlike the district court, the court held that it was plausible that where statements contain debt collection language that is not specifically required by TILA or its incorporated regulations, and the other context of the status of the account, the disposition of the account, can constitute attempts to collect or induce payment on a debt. The 11th Circuit made a point to note that communications can serve a dual purpose by being both informational and debt collection. And before we get into the nitty-gritty of how the 11th Circuit arrived at its decision, it's also worth noting that there was a written dissenting opinion that disputed the majority's holding and found, in line with some of the prior cases that we'll discuss a bit later, that those were more persuasive given the overall context of the statements at issue here. The dissent did also reference cases from other circuits, the 6th Circuit, the 3rd Circuit, and the 8th Circuit among them, on this issue, and sought to distinguish those cases from the case at bar here. But I'll kick it back over to Nick to discuss the particulars of this opinion and why the 11th Circuit ruled as it did.
So I think the Daniel's decision at a 10,000 foot view seems like maybe it wasn't as unexpected as some people are making it out, but the details of the decision are really interesting, really useful, and I think shed a lot of light on what the decision is and what the decision isn't, which is pretty important to understanding how to handle it going forward. I will say at the outset that there is a pending motion for rehearing on Bonk. There was also a dissenting opinion that basically was consistent with the prior decisions and would have found that the case was properly dismissed and did not plausibly allege a violation of the FDCPA because the monthly mortgage statement wasn't an attempt to collect debt. So it remains to be seen if any of these holdings will be, if rehearing will occur, if it will survive rehearing, if it'll be watered down. Candidly, I don't necessarily think that that's likely, owing largely to the nature of these details and how circumscribed the decision really is when you break it down. So a lot of the discussion of this case, and probably its most impactful discussion, is about the Mini Miranda. So the Mini Miranda is the statement that the FDCPA requires under certain circumstances and requires you to say that this is an attempt to collect a debt and all information obtained will be used for that purpose. So a body of case law had developed that held that the presence of the Mini Miranda did not necessarily mean that the communication was an attempt to collect a debt, which is at first glance a bit of an illogical holding, seeing as the communication itself says that it is an attempt to collect a debt. A lot of that case law arose under the earlier iterations of the FDCPA, pre-amendment iterations of the FDCPA, that required the Mini Miranda not just in initial communications, but even in subsequent communications, and therefore would oftentimes require the Mini Miranda in circumstances where it wasn't actually an attempt to collect a debt under the definition. So you would get this like logically incongruent situation where you would have the Mini Miranda on things where it really didn't belong. You were obligated to do it under TILA or under the FDCPA rather, but it wasn't really an attempt to collect the debt. So the 11th Circuit pointed out in Daniels that the act has been subsequently amended and that the overuse of the Mini Miranda is much of the conflict and that issue that was an inherent part of the early version of the statute has been removed, and that for purposes of a motion to dismiss, where the inferences are drawn in favor of the pleader, of the plaintiff, that saying that the presence of the Mini Miranda is completely irrelevant to whether or not the communication is in connection with the collection of a debt is incorrect. So the case law earlier, like the Al-Asid case, had said that the presence of the Mini Miranda is not dispositive. It doesn't mean that it definitely is an attempt to collect a debt. You still engage in a totality of the circumstances test. And that was extended by the Daniels decision and said that it is a totality of the circumstances test. And we consider the presence of the Mini Miranda to be one of many factors. And we reject cases that say it was a complete non-factor, at least on a motion to dismiss stage. It's very interesting how much tiptoeing the decision does about trying to clarify what it is deciding and what it is not deciding. It specifically says that it didn't decide the issue for purposes of summary judgment and is not prejudging the issue as a matter of law, that it is an attempt to collect a debt, but rather is rejecting the rationale that the district court used, which had been used in many other cases, that treated the Mini Miranda as meaningless for purposes of analyzing whether or not it was an attempt to collect a debt. So the other specific details that the court noted it felt would at least render the claim plausible for purposes of a motion to dismiss is that the mortgage statement obviously does discuss the debt. It contained entries for various pieces of information about the debt. Those are obviously required by TILA. Nonetheless, in the full context of the analysis, it is something that gives it a nexus to the debt, which is in and of itself a requirement for it to be in connection with the collection of a debt. But the other thing that they looked at was the history of the parties. So Daniels had been involved in foreclosure litigation. She had prevailed in the foreclosure litigation by proving the presence of a modification. And the basis for her allegation that the mortgage statements were inaccurate was that they did not reflect the terms of the modification that had been adjudicated in a separate action to exist, to be enforceable, and that it did not reflect the court's ruling. The court had made a ruling that certain amounts of interest would be put at the back of the loan. That wasn't done in the monthly mortgage statements. So the history of the parties, the court felt, was also relevant. So I think if you had a borrower who was not in default, who was then saying that you were attempting to collect a debt and that you had misrepresented the amount of their interest, maybe the court would take a different tact about whether or not it was an attempt to collect a debt or just an informational disclosure if the history of the parties hadn't been one that included a lot of attempts to enforce the obligation and claims of default and things like that. So the other factors that the court looked at and the other language that it found relevant was that the mortgage statement solicits payment. The statement attached a monthly coupon. The coupon indicated late fee information. I know some of you are probably frustrated by that finding of the 11th Circuit, because once again, that is part of the form TILA statement. So it's not something that you would only send to a borrower in default, or that you would only send if you were trying to collect a debt. You're probably going to include that coupon with every single person, even in purely informational disclosures. Nonetheless, as a factor, it did suggest, the absence. In some cases, I think the presence of these things alone is certainly not enough. The absence of them would be probative to a finding that it wasn't debt collection, and so that's why it gets some play in the opinion. The other language that the 11th Circuit keyed in on, I think this is probably the most important language, and probably what tipped this over the edge, aside from the court's desire to retreat from the idea that the Mini Miranda is meaningless, at least on a motion to dismiss. I think the 11th Circuit also wanted to look at some of these rulings that were being pretty liberal about the inclusion of other language not required by TILA, and whether or not that can transform a TILA statement into a dual purpose statement that is both complying with TILA and engaging in some kind of debt collection. So TILA statement obviously does require referring to late fees and information like that, but some of this language is not required by TILA. It's not in the usual form, in the standard form, and the court pointed that out. So the statements, these bullet points here are quotes from the statement. You're late on your mortgage payments. Failure to bring your loan current may result in foreclosure and loss of your home. SPS has completed the first notice of filing required to start a foreclosure. Paying your mortgage on time is an important obligation, so please pay on before the payment date. Payments are not considered paid until received and posted to your account. That SPS furnishes information to Consumer Reporting Agency. You're hereby notified that a negative report reflecting on your credit record may be submitted to a credit reporting agency if you fail to fulfill the terms of your note and mortgage. So some of these are required by TILA, others are not, and the language in some of them where a disclosure of that nature is required is a little bit stronger than perhaps would have been necessary to strictly comply with the statute. So the Daniels decision looked at all of this and said that it was enough on a motion to dismiss stage to at least submit to a fact finder the factual question of whether or not an animating purpose of the communication was to collect the debt. So this is sort of the takeaway holding. It says, we hold, consistent with our decision in Reese and Kacharis, that a monthly mortgage statements required by the TILA's regulations can plausibly constitute communications in connection with the collection of a debt under the FDCPA and in connection with collecting a debt under the FCCPA if A, they contain this as an attempt to collect the debt language, B, they request or demand payment of a certain amount by a certain date, C, they provide for a late fee if the payment is not made on time, and D, the history between the parties suggests that the statement is an attempt to collect on a disputed debt. So you will see two of these factors in almost every monthly mortgage statement. You will not necessarily see the Mini Miranda or a history between the parties to suggest an attempt to collect a debt in every monthly mortgage statement case. So it's clear that the Daniels case is not saying that every monthly mortgage statement is an attempt to collect a debt just because it recites information about the debt. However, the argument which had been deployed with a lot of success, and I made the argument extensively and have won a number of cases throughout the years on the argument that either periodic statements can never violate these statutes because they're legally required and their animating purpose is not debt collection but compliance with federal law, and that you send these statements to people whether they're in default, whether they're overpaying, whether they're on time. That was the argument, that the purpose of it clearly wasn't debt collection if you were sending it to people who didn't have any kind of arrearage. That isn't going to work. However, it's also not the flip side that each of these is an attempt to collect a debt. And so it's going to be a multi-factor analysis. But Sara will discuss a little bit more how to synthesize the decision going forward.
So what is the truth? My favorite GIF. What is the truth? Where does that leave us with the case law that we have been relying on up to this point? And we have a long line of cases that, as Nick had mentioned, had been used with a lot of success in avoidance of FDCPA and FCCPA liability. Unfortunately, a couple of those cases have specifically either been disapproved and walked back on or distinguished in some sort of meaningful way by the Daniels opinion. Two of those cases are 2018 cases out of the Southern District of Florida, the Jones case and the Zavala case. In both cases, the court found that monthly mortgage statements that had been sent pursuant to TILA and Reg Z did not constitute debt collection within the meaning of the FCCPA and FDCPA. Both cases were expressly by name disapproved by Daniels on the basis we had discussed previously. The Green case, on the other hand, was an 11th Circuit case from 2019 that held that monthly mortgage statements that did not rise above what constitutes a garden variety type of statement required by TILA more or less created a sort of substantial compliance standard whereby statements that did not deviate from TILA's requirements or otherwise deviate from the CFPB model forms did not suddenly become debt collection communications. Now, the Daniels court did not undercut its own decision in Green, but did make an attempt to meaningfully distinguish it by noting that the Green case did not specifically include that Mini Miranda language. Now, cases between Daniels and Green between 2019 and the current opinion had relied on Green and that garden variety language to state that the inclusion of the Mini Miranda did not create debt collection communications where the statements did not otherwise deviate. And that's something that the Middle District of Florida in Daniels before the case went up on appeal also relied on in its findings that the statements at issue were informational and not debt collection. And there are plenty of other older federal and Florida state opinions that now have become riskier citations because they relied on the prior body of case law stating that TILA and Reg Z compliance statements did not become debt collection communication. So we do have to be careful moving forward to the extent that litigation strategies necessitate skipping the motion to dismiss stage and moving towards summary judgment, that we're not relying heavily on cases that have been expressly disproved by Daniels and making meaningful distinguishing making note of distinguishing factors where appropriate. And so now Nick will touch upon litigation strategies moving forward and internal business considerations in light of the Daniels opinion.
Thanks, Sara. So a couple of different things. This case is obviously, like we said, still subject to a motion for rehearing, and it may change. Assuming that it does not, and even in the midst of some uncertainty on the issue, I think the big takeaway from Daniels is to consider your statements and to do a reanalysis of the overuse of the Mini Miranda. I think for a long time, the Mini Miranda was treated as something that you really only had downside if you didn't include it and you needed it. But if you said it and you didn't need it, it was no harm. And so a policy, a policy and practice around the industry in a lot of different companies overused the Mini Miranda and perhaps didn't keep up with some of the changes to the law, to the FDCPA about when it is and is not necessary. I think now the Green case definitely gives cause to take a fresh look at that. It definitely was a downside. The Green case, they distinguish almost exclusively on the grounds that it didn't have the Mini Miranda. And some of that is because they have to find a way to distinguish the decision from something that's actually in the opinion. and that was discussed in the opinion. So, but it seems clear that the line of cases that say the Mini Miranda is meaningless in the analysis of whether or not a communication is in connection with the collection of a debt and therefore covered by the FDCPA is not likely to be an argument that continues to have the strength that it once did. So definitely take a look at that and analyze if there are situations where you're very obviously overusing the Mini Miranda. It still remains true that for the most part, the penalty exceeds the crime for not including it, and that in a lot of different circumstances, there will not be a penalty for overusing it. But this case certainly is an illustration of one such circumstance where there was. The other issue is to consider your jurisdiction. So the dissent says that there's now a circuit split on the issue. The 11th went through those cases and said no, there's not a circuit split, and went through and provided grounds to distinguish those cases. But what is clear is that the Daniels case, if it becomes the law of the 11th Circuit and rehearing is denied, or the decision remains after rehearing, the 11th Circuit will have the stronger law on the issue than a lot of other circuits, and that we've seen the issue be handled differently in other jurisdictions regarding whether or not mortgage statements are more or less likely to be treated as an FDCPA violation, or if they're going to be given some kind of carve out or different kind of treatment because of their legally required nature. The other thing is, if you're in cases where you have to litigate this decision and it's being cited as adverse authority for a position you're taking, definitely consider the procedural posture. The Daniels opinion is littered with references that it is only deciding whether or not Daniels could plausibly state a claim based on a monthly mortgage statement, and rejecting the argument that because it was a monthly mortgage statement, that was grounds for dismissal, full stop. The court wants a more detailed analysis, but did not prejudge whether or not Daniels would even win in a motion to dismiss that analyzed, that applied a different standard, or a motion for summary judgment or trial. So now I would caution everyone not to read too much into that. I think part of that is the court trying to be smart about its decision and save for another day things that it didn't have to decide in this decision. That doesn't mean, though, that if this case comes back up after summary judgment in favor or against Daniels, that a very similar result won't be reached. But it certainly is in the opinion throughout that it is not good law to cite at a summary judgment stage. There's ample quotations to give from the decision to suggest that your adversary needs to look at other cases in those procedural postures. But I think it's prudent to look at some of these cases when you're looking at settlement and look at them in a different light. I think that there was a lot of good case law in the Middle District of Florida, the Southern District of Florida. The Green case and the 11th Circuit, even though it was an unpublished decision, was a good site that many courts thought forecast how this case would have gone. And so I think that, when we're counseling our clients on these kinds of cases, we're going to have to give them far less rosy analysis on the status of all that case law and the risk that the case presents. And that means, look for your leverage points to see if these cases can be economically settled. So, can you do a set off with an unpaid balance? Can you use a proposal for settlement or offer of judgment to create a pressure point? Because these claims are definitely more risky than they were before. And you'll want to take a look at the other strengths of your case, or the ability to use things like arbitration agreements, to try and mitigate the risk of these cases rather than an over-reliance on the fact that it was a monthly mortgage statement. So a few more business considerations post Daniels is whether where you're going to send these monthly mortgage statements. So whether or not they should be sent to counsel, or should they be sent to the borrower. And we've seen also that it's a good time to take a look at operations to verify the procedures for processing letters, making sure that bankruptcy orders, discharge orders, the kinds of things that can very likely lead to FDCPA violations if they're not properly noted. Make sure that those systems are working, that they update things timely, that vendors are doing that to avoid preventable FDCPA violations. And the other issue is to look at whether or not the debt is disputed. That was something that came up in the Daniels case because of the history of foreclosure and because Daniels had prevailed on some arguments that the lender had not properly accounted for a loan modification. It made the conduct in this case seem worse and seem more plausible when Daniels said that it wasn't just an innocent mistake, that it was harassing or deceptive or an attempt to hoodwink her. The history of the case very much mattered as far as the plausibility of that. And so it's worth, looking at what the posture and history between the parties is in these kinds of cases, because the court is it looks like going to place a renewed emphasis on that when it's looking at these kinds of cases and the proofs. So thank you guys all for joining us. If there are any questions, we'd love to answer them for you. You can definitely email us if you think of any after the fact. And we look forward to helping you guys in the future with these kinds of cases.